to the state. Are you seeking pretrial detention for Mr. Rowe?
No, Your Honor, not at this time.
Okay. Are you seeking a bond?
Yes, Your Honor, we are seeking a bond. As of right now, this defendant is currently charged with burglary of a dwelling. The facts surrounding this case are that the defendant allegedly threw a brick through a vacant dwelling to gain entry and then ended up taking some property that was inside the dwelling. As of right now, the defendant, we believe, is from Jamaica and has an ICE hold. He also has a pending felony in Walton County for an aggravated assault by threat with a deadly weapon. Given that the defendant was out on bond in that open aggravated assault with by threat with a deadly weapon case, and given the ICE hold, Your Honor, the state is going to be requesting a $100,000 cash professional bond in this case. We do feel as though there is concern for the safety of the community, and we would like a higher bond on this given the burglary of a dwelling and the fact that he threw a brick through a window. So that's the state's position, Your Honor.
Thank you. Yes, sir. Mr. Koch.
Yes, Your Honor. We were pointing on April 9th. I did not see that my client had those open charge right now. So I did not see that, but I did see there is an immigration hold on my client as of today. I would just like to point to the risk assessment score provided at first appearance. It states that my client does have a job at Walmart. He has a home. He has no prior FTAs. He did provide a phone number, and he did have a risk assessment score of a 9. And just looking at the nonviolent felony, he does score in that low category. I'm asking for a $5,000 cash professional dollar bond for the burglary of the dwelling and a $1,000 cash professional bond for that petty theft, Your Honor.
Okay. And this is something that I don't know. In the first appearance information, that sheet that's filled out, when it says violent felony and it has 2 in this instance, does that include this one, or is that in addition to this one?
Judge, could you repeat that question one more time
Yeah,
for me?
it says violent felony and it says 2. Is that excluding the subject case that's in front of the court, or does that include the subject case?
Hold on one moment, Your Honor. I can try to figure that out.
If I had to, just my only input, Your Honor,
Yes, sir.
on that, just because on, when they go through the risk assessment, they go the current most serious charge. For this current case, they have other listed, so they didn't even put violent down. So I guess, I'm just trying to answer that question posed to the defense. I guess that's not including these charges, Your Honor. That would be my just reading their paperwork, Your Honor.
Understand.
I think what they may be doing is sometimes when we go into the system, if, for example, somebody got charged with 4 counts, it may have pled down to only one of those counts and they'll see it. I think that's probably what's happening here. And Walton originally was charged with, the open case was originally charged with multiple violent offenses, and it's since been actually been filed on one of those violent offenses, which was the aggravated assault. So as of right now, based on the state's quick cursory look at the record, I believe there's only 2 violent charges. It would be this aggravated assault that's open in Walton as of right now, and then this burglary of a dwelling causing damage over $1,000.
Thank you. Mr. Rowe, I did read through the arrest report, the affidavit from that. I didn't know about the Walton County case until the state just brought that up today. Even though it may be somewhat academic as far as whether you get out of jail or you don't, if there's an ICE hold on you, you're still entitled to a bond for this case. I also noted, and again, I don't say this where you'll say anything. I don't want you to say anything factually about your case because it can be used against you. Everything's being recorded. But I did note in here that you allegedly stated that you did this to get your keys back, which were inside the residence. Mr. Rowe, I am going to set your bond at $100,000 cash or professional. So when will I see Mr. Rowe next? Okay. Yes, ma'am, and then count to $1,000 cash or professional. So, Mr. Rowe, I'll see you on May 16th. Okay. Thank you, sir. Thank you, ma'am.
Your Honor,
Mr.
this
Lee.
is Mr. Jermaine Lee in 24 CF 754.
Is the state seeking pretrial detention for Mr. Lee?
We are not at this time, Your Honor.
Okay. What bond are you seeking?
Your Honor, the state is seeking a $250,000 cash professional bond with this charge. The reason being, the first reason being is the nature of these allegations. The allegations are that he used a firearm pointed at the clerk and robbed a store clerk of approximately $1,500. That store clerk could not actually speak English. And so didn't actually immediately call until he got home, told his brother, who was the manager, and then that was when this investigation started. There is a screenshot that the state feels accurately reflects the defendant, or a screenshot from the surveillance that the state feels accurately reflects the defendant in being inside of the convenience store with the gun. I also want to draw this court's attention to this defendant's prior record in particular. In 2020, August of 2020, he was sentenced and adjudicated on a robbery without a firearm. He wasn't released until July 18th of 2023. So, I mean, it's been about a little over 9 months since he's been released from a very similar charge, and then he actually escalated it by allegedly committing this robbery with a firearm. I also want to point out in 2018, he was adjudicated guilty of assault, but also in that case of a failure to appear for a misdemeanor. And then as we go down, I know this was somewhat farther away, but in 2006, he was also found guilty of a failure to appear for a felony. He also has, I believe, one fleeing and attempting to elude with reckless driving. So there is a concern for a flight risk, but there is also the primary concern here with the state and wanting to set a $250,000 cash professional bond is the concern for the public. It seems somewhat evident that the previous incarceration that this defendant served didn't necessarily get the point across in terms of following the law and making sure that the public is safe. Given that we saw in 2018, we see an assault, then in 2020, we see a robbery without a weapon, and now in 2024, we have a robbery with a weapon mere 8 or 9 months after he was released from incarceration for the robbery. The state feels as though there is a serious concern for the safety of the public, and we would respectfully request this bond be set at $250,000 cash professional. Thank you.
Okay, thank you. Mr. Lee, you may have seen me nod. I nod because I understand the argument of the attorneys. It doesn't necessarily mean that I agree with them, but I understand where they're coming from. If I if I don't understand something, I'll stop and say, wait a minute, I don't understand, because I read through and I did do my homework and read through the arrest report. That's all I can go on as far as the alleged facts. But I just wanted you to know that I may not be buying everything that an attorney's trying to sell me, but I understand what their argument is. Yes, sir.
Your Honor, as far as Mr. Lee's prior record, in reviewing and I know you were asking Mr. Koch about I believe you were asking him about the entry on the first appearance information.
Yes, sir.
So I prior to you engaging in that with Mr. Koch, I had looked up Mr. Lee's prior record, and I was looking at that, and I thought, well, wait a second. Unless there's a definition of violent felony that is kind of loose, Mr. Lee's priors, I think Mr. Gomez accurately reflected them. And I will be the first to say that robbery with a firearm is obviously a crime of violence, but Mr. Lee served 1 year and 3 days in DOC on that robbery with no firearm. That's his only time he's ever been sentenced to prison. The fleeing and eluding took place in 2006. Mr. Gomez referenced another case from 2008. So he doesn't clearly have no history. I can't stand here and say this is the first time he's ever been in trouble. Clearly he hasn't been, but I don't know where that number 5 comes from. Certainly the instant offense would qualify for 1. Maybe fleeing and eluding is considered a crime of violence. I don't know, because I don't know what the definition of it is.
Yes, sir.
I did meet with Mr. Lee at the Okaloosa County Jail, I believe yesterday. No, not yesterday, Tuesday. In speaking with Mr. Lee advised me that he offered to give his own DNA to the investigators when they showed up, that he consented to a search. According to Mr. Lee, law enforcement never found any evidence of a gun. He strongly disputed the entry in the police report about a family member identifying him. I find it a little odd that OCSO wouldn't put the actual name of the family member in there, but certainly at this point, this is so early that we'll figure that out. Mr. Lee is going to request, and he strongly denies that he did this. At this point, these are allegations. He is requesting that the court consider an ROR bond with a GPS monitor. I think that's a little low, frankly. I think a more appropriate bond probably would be in the neighborhood of $10,000 cash or professional, given the nature of the charge. But he's requesting an ROR bond at this point. He has no problem with the GPS monitor and wearing that and waiting until that's attached before his release. But rarely have I met with a client with these type of charges and immediately starts giving me information about, well, I did this and I gave him this and I gave him this. If that's true, it kind of is in stark contrast to the allegations. And I have not seen the surveillance footage that Mr. Gomez was talking about, so I don't have any way to confirm or say, well, I don't know, that kind of looks like you or it doesn't look like you. But he is requesting the court consider an ROR bond, but he does have no objection to a GPS monitor and pretrial services.
Okay, thank you. Mr. Lee, I'm just staring at that paragraph that says, during the investigation, it was learned the Quick Shop had working surveillance cameras, and I'm reading through that over and over again. The next paragraph after that talks about family members, but I don't see, you know, numerous anonymous tips were received identifying the defendant as Mr. Lee. Mr. Lee, at this point, all I can do is base my decision based on the very limited facts that I have. As Mr. Klein stated, as he starts getting discovery and going through that, he may get some additional information and say, Judge, he does a bond hearing and says, because of this, I want you to readdress the bond. But at this point, the allegations are egregious, and so I am setting your bond at $250,000 cash or professional. So will I see Mr. Lee on March 16th? May 16th, I'm sorry. Okay. So I'll see you then, Mr. Lee. Thank you. I think that's all we have until 1:30, correct? Thank you. We're adjourned. I'm going to finish up my stuff. Y'all can go ahead and go about your business. Thank you.